the fourfold duty of a lawyer is his duty to the public or society, which is provided under the Canons 1 to 6 of the Code of Professional Responsibility. Let's start with Canon 1. A lawyer shall uphold the Constitution, obey the laws of the land, and promote respect for law and legal processes. Under this canon, it embodies the twofold duty of a lawyer, which is, number 1, to obey the laws and the legal processes, and number 2, inspire others to maintain respect and obedience thereto. Next, Rule 1.01 under Canon 1 provides that a lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. Please note that to warrant disciplinary action, the act must not only be merely immoral, but grossly immoral. Grossly immoral conduct means that the conduct is so corrupt and false as to constitute a criminal act, or so unprincipled or disgraceful as to be reprehensible to a high degree. Another rule under Canon 1 is Rule 1.02. It provides that a lawyer shall not counsel or abet activities aimed at defiance of the law or lessening confidence in the legal system. Let's now proceed to Rule 1.03. It provides that a lawyer shall not, for any corrupt motive or interest, encourage any suit or proceeding or delay any man's cause. This rule is aimed against the practice of barratry and ambulance chasing. Barratry is an offense of frequently exciting and stirring up quarrels and suits either at law or otherwise. Please note that barratry is not crime under the Philippine laws, however, it is prescribed by the rules of legal ethics. On the other hand, ambulance chasing is an act of chasing victims of accidents for the purpose of talking to the said victims or relatives and offering his legal services for the filing of a case against the person who caused the accident. Lastly, Rule 1.04 of Canon 1 provides that a lawyer shall encourage his clients to avoid and or settle a controversy if it will admit of a fair settlement. It is the duty of the lawyer to temper his client's propensity to litigate and resist his client's whims and caprices, for the lawyer also owes duty to the court. So here is an example of case under Canon 1, which is the case of Attorney Raquel Co. in relation to the report on the financial audit conducted on the books of account of Attorney Co. Facts: Attorney Co is a former clerk of court of the RTC in Eastern Samar. He was found guilty of gross misconduct for his failure to make a timely remittance of judiciary funds in his custody. Since his malfeasance prima facie contravened Canon 1, Rule 1.01 of the Code of Professional Responsibility, which is a lawyer shall not engage in unlawful conduct, the Supreme Court order to show cause why he should not be disciplined as a lawyer and as an officer of the court. Attorney Co explained that his failure to make a timely remittance of the cash deposited with him was inexcusable. He maintained his contention that he kept the money in court safety vault and never once used it for his own benefit. It was held by the Supreme Court that even though he was in good faith, his action was a breach of his oath to obey the laws as well as the legal orders of the duly constituted authorities and of his duties under Canon 1 Rule 1.01 of the Code of Professional Responsibility. As servants of the law and officers of the court, lawyers are required to be at the forefront of observing and maintaining the rule of law. They are expected to make themselves exemplars worthy of emulation. The least a lawyer can do in compliance with Canon 1 is to refrain from engaging in unlawful conduct. By definition, any act or omission contrary to law is unlawful. The presence of evil intent on the part of the lawyer is not essential in order to bring his act or omission within the terms of Rule 1.01, which is specifically prohibits lawyer from engaging in unlawful conduct. Attorney Co's conduct was not only far from exemplary, it was unlawful as well. For this, he must be called to account. Attorney Co is ordered to pay fine.
Canon number 2. A lawyer shall make his legal services available in an efficient, convenient manner, compatible with the independence, integrity, and effectiveness of the profession. Rule 2.01. A lawyer shall not reject, except for valid reasons, the cause of the defenseless or the oppressed. What does it mean when we say defenseless? Those who are not in a position to defend themselves due to poverty, weakness, ignorance, or other similar reasons. Oppressed. Those who are the victims of cruelty, unlawful exaction, domination, or excessive use of authority. In Rule 2.02, in such a case, even if the lawyer does not accept a case, he shall not refuse to render legal services or legal advice to the person concerned, if only to the extent necessary to safeguard the latter's rights. Rule 2.03. A lawyer shall not do or permit to be done any act designed primarily to solicit legal business. No advertisement by lawyers is allowed. However, these are permitted reputable law lists in a manner consistent with the standards of conduct imposed by the Canons. Advertisements are simple announcement of the existence of a lawyer. Ordinary and simple professional cards are allowed. In our first case, Linsangan versus Tolentino, the facts are Tolentino with paralegal Labiano convinced Linsangan's clients to transfer to him and promise them financial assistance. Labiano's calling card here contains the phrase financial assistance, which was clearly used to entice clients. The issue in this case is whether or not Tolentino violated the Code of Professional Responsibility, and the Supreme Court held that yes, Tolentino violated the Code of Professional Responsibility. We are reminded that lawyers are only allowed to announce their services by publication in reputable lists or use of professional cards. And these professional cards may only contain the following details: the lawyer's name, name of the law firm in which he is connected, the address, telephone number, and special branch of law practice. A lawyer who advertises his talent or skill is to commercialize the practice of law, degrade the profession in the public's estimation, and impair its ability to efficiently render the high character of service. In Rule 2.03, we are reminded that a lawyer shall not charge rates lower than those customarily prescribed unless the circumstances so warrant. In this case, Attorney Nicomedes Tolentino was suspended from the practice of law for a period of 1 year and was sternly warned that future actions shall be dealt with more severely. The last rule for Canon number 2, Rule 2.04. Lawyers shall not charge rates lower than those customarily prescribed unless their circumstances so warrant. For example, there are acceptance fees that are already prescribed. For example, in municipal circle court, civil cases are charged with 35,000 pesos. For criminal cases, 40,000 pesos. And when the case reaches the Supreme Court, the acceptance fee for civil case is 150,000 pesos, and for criminal case is also 150,000 pesos. These are prescribed rates that lawyers must be followed, and any charge or lower rates given to our clients is a violation of Rule 2.04 of Canon number 2.
Moving forward to Canon 3. Under Canon 3, it provides that a lawyer in making known his legal services shall only use true, honest, fair, dignified, and objective information or statement of facts. While it is true that lawyers need to earn money for a living, lawyering shall not and never be considered as a business. It is a profession in which duty to public service, not money, is the primary consideration. Rule 3.01. A lawyer shall not use or permit the use of any false, fraudulent, misleading, deceptive, undignified, self-laudatory, or unfair statement or claim regarding his qualifications or legal services. Rule 3.02. In the choice of a firm name, no false, misleading, or assumed name shall be used. The continued use of the name of a deceased partner is permissible, provided that the firm indicates in all its communication that said partner is deceased. The first paragraph in this rule applies to when a lawyer uses in their letterheads another name of a lawyer who is not his actual partner, or they practice law independently. This is clearly misleading to the public. Further, in the second paragraph, in the case of Sisip, Salazar, Feliciano, Hernandez, and Castillo, the partners of Attorney Alexander Sisip and Attorney Herminio Azeda prayed that they may be allowed to continue using the name of their deceased partners. The court denied their petition, and they were ordered to drop the Sisip and Azeda from their respective firm names. The court pointed out in this case that the practice of law is intimately related to the administration of justice and should never be considered like an ordinary money-making trade. The petitioners' desire to preserve the identity of their firms in the eyes of the public must bow to the legal and ethical impediment, meaning the partners might be trying to uphold a brand through their deceased partner's name. Rule 3.03. Where a partner accepts public office, he shall withdraw from the firm, and his name shall be dropped from the firm name unless the law allows him to practice law currently. Under Rule 138, those who may practice law are those duly admitted in the bar, in good moral standing, to name some requirements. However, there are also some restrictions in practicing law, such as those who are working at public office as senators, as member of the House of Representatives, sanggunian members, and retired justice or judge. Lastly, Rule 3.04. A lawyer shall not pay or give anything of value to representatives of mass media in anticipation of or in return for publicity to attract legal business. Again, lawyering is not a business. It is not a money-making trade. It is a profession that is aimed towards public service and in the administration of justice.
Canon 4. A lawyer shall participate in the development of the legal system by initiating or supporting efforts in law reform and in the improvement of the administration of justice. It is incumbent for a member of the Philippine Bar to be in solidarity with the legal profession, to contribute to the development of the legal system. The basic means thereof is by actively participating in the efforts of the Integrated Bar of the Philippines in its activities, as well as being faithful in paying the prescribed monetary contributions and fees as way of giving support for the development of the legal system. On January 16, 1973, the Integrated Bar of the Philippines, or IBP, was organized as official, that is, a state-initiated body through Presidential Decree 181 pursuant to Republic Act 6397, giving power to the Supreme Court to adopt the rules of court, paving the way for the integration of the Philippine Bar. Hence, this body is yoked with the responsibility to ensure that the legal profession, as enunciated in Canon 4 of the CPR, is guarded and enforced. More so, the IBP was tasked not only to ascertain the advisability of integration of the bar, but even more, to serve as a common vehicle for the court and the bar in fashioning a blueprint for integration and putting the same into actual operation. Thus, a new bar passer is not only required to take the lawyer's oath and sign the roll of attorneys in the Supreme Court, but also is required to become a member of the Integrated Bar of the Philippines and remain as a member thereof in good standing. In the case of AC 1928 of December 19, 1980, in the matter of the IBP membership dues delinquency of Attorney Marcial Edilion, the Supreme Court held that the integration of the Philippine Bar has become an imperative means to raise the standards of the legal profession, improve the administration of justice, and enable the bar to discharge its public responsibility fully and effectively. Canon 5. A lawyer shall keep abreast of legal developments, participate in continuing legal education programs, support efforts to achieve high standards in law schools, as well as in the practical training of law students, and assist in disseminating the law and jurisprudence. It is imperative that lawyers are looked upon by the society as persons of dignity and high intellect. Therefore, it is integral that such is not a mere presumption, but must be evidently demonstrated by the practitioners of the legal profession. This ensures that whatever is invoked or imploded are consonant to the most current applicable laws or Supreme Court decisions. On January 29, 1988, the Supreme Court promulgated the case of DeRoy versus Court of Appeals in GR number 80718 on the issue whether the petitioners cannot seek refuge in the ignorance of their counsel regarding the rule for their failure to file a motion for reconsideration within the reglementary period on the ground that said jurisprudence was not published in the official Gazette of the Philippines. The Supreme Court asserted the negative. It was held by the Supreme Court that there is no law requiring the publication of Supreme Court decisions in the official Gazette before they can be binding and as a condition to their becoming effective. It is the burden and the bounden duty of counsel as lawyer in active law practice to keep abreast of decisions of the Supreme Court, particularly where issues have been clarified, consistently reiterated, and published in the advanced reports of the Supreme Court decisions, and such publications as the Supreme Court reports annotated and law journals. Concurrently, the mandatory continuing legal education program is implemented, which is required in order for lawyers to be insured with the updates and other pertinent legal developments. This is enunciated in Bar Matter number 850, promulgated August 22, 2000, where continuing legal education is required of members of the Integrated Bar of the Philippines to ensure that throughout their career, they keep abreast with law and jurisprudence, maintain the ethics of the profession, and enhance the standards of the practice of law. And lastly, there is AM number 19-03-24-SC or Rule 138A, otherwise known as the Revised Law Student Practice Rule, in which a salient feature of the revised rule is that a law student must now be certified to be able to engage in the limited practice of law. Under this rule, a student shall apply for level 1 or 2 certifications depending on his compliance with the requirements thereof, and in so doing, upon issuance of said certifications, may perform limited practice of law provided under Bar Matter number 730 of June 13, 1997, that a law student shall be supervised by a member of the bar in good standing. Within the law student practice rule is the clinical legal education program, which is an experiential, interactive, and reflective credit-earning teaching course with the objectives of providing law students with practical knowledge, skills, and values necessary for the application of the law, delivery of legal services, and promotion of social justice and public interest, especially to the marginalized, while inculcating in the students the values of ethical lawyering and public service. It consists of learning activities covered by this rule undertaken in either 1. Law clinic, or 2. Externship, which shall incorporate the teaching of legal theory and doctrines, practical skills, as well as legal ethics. Now, let's ask a question whether Rule 138A is absolute. In the case of Cruz versus Judge Mijares, in GR number 154464, September 11, 2008, Plaintiff Cruz being a fourth-year law student, anchors his claim on Section 34 of Rule 138 of the Rules of Court that a non-lawyer may appear before any court and conduct his litigation personally as party litigant to a civil case in a lower court or inferior court for a case about abatement of nuisance to which respondent Judge Mijares denied. So the issue at hand is whether Cruz is under Rule 138A or he may be entitled to Section 34 of Rule 138 of the Rules of Court. The Supreme Court construed in favor of the latter. It was subsequently clarified in Bar Matter 730 that by virtue of Section 34, Rule 138, a law student may appear as an agent or a friend of a party litigant without need of the supervision of a lawyer before inferior courts. Here, we have a law student who, as a party litigant, wishes to represent himself in court. Canon 6. These canons shall apply to lawyers in government services in the discharge of their tasks. Rule 6.01. The primary duty of a lawyer engaged in public prosecution is not to convict, but to see that justice is done. The suppression of facts or the concealment of witnesses capable of establishing the innocence of the accused is highly reprehensible and is cause for disciplinary action. Prosecutors are lawyers in government service who are basically engaged to prosecute offenses on behalf of the people of the Philippines. During the 8th United Nations Congress on the Prevention of Crime and the Treatment of Offenders, which happened in Havana, Cuba, between August 27 to September 7, 1990, our judiciary adopted the guidelines on the role of the prosecutors, which include, among others, that prosecutors shall perform an active role in criminal proceedings, including institution of prosecution, and where authorized by law or consistent with local practice, in the investigation of crime, supervision over the legality of these investigations, supervision of the execution of court decisions, and the exercise of other functions as representatives of the public interest. Rule 6.02. A lawyer in the government service shall not use his public position to promote or advance his private interests, nor allow the latter to interfere with his public duties. When a member of the bar renders service to the government, said lawyer is under the oversight of both the Integrated Bar of the Philippines and the Civil Service Commission. In both authorities, a member of the legal profession may be subjected to the administrative or disciplinary sanctions. Therefore, he or she is not only expected to demonstrate fidelity to the lawyer's oath, but also oaths of office for public officers and employees. These also include some restrictions as regard to their practice of law. In Section 7B.2 of Republic Act 6713, otherwise known as Code of Conduct and Ethical Standards for Public Officials and Employees, it says, public officials and employees during their incumbency shall not engage in the private practice of their profession unless authorized by the Constitution or law, provided that such practice will not conflict or tend to conflict with their official functions. In addition, under Section 35, Rule 138 of the Revised Rules of Court, we can find that no judge or other official or employee of the superior courts or of the office of the Solicitor General shall engage in private practice as a member of the bar or give professional advice to clients. And as regard to lawyers who are elected in government positions, a special provision is applied under Section 90 of RA 7160, also known as the Local Government Code of 1991, providing the scopes and limitations of the practice of profession, and of course the 1987 Philippine Constitution likewise provide for the prohibition thereto. On April 1, 2003, a member of the IBP, serving as OIC of the Legal Services of CHED, was disbarred for using her position when she took from various complainants amounts of money in exchange for the expedition of the services they sought from the Commission, which includes correction of names among others. The case of Bitriolo versus Dasig in AC number 4984 decided on the issue whether respondent attorney at law as officer in charge of the legal services of CHED may be disciplined by the court for her malfeasance, considering that her position at the time of filing of the complaint was Chief Education Program Specialist, Standards Development Division, Office of Programs and Standards, Head of CHED. The Supreme Court held the affirmative. The court said, generally speaking, a lawyer who holds a government office may not be disciplined as a member of the bar for misconduct in the discharge of his duties as a government official. However, if said misconduct as a government official also constitutes a violation of his oath as a lawyer, then he may be disciplined by this court as a member of the bar. Rule 6.03. A lawyer shall not, after leaving government service, accept engagement or employment in connection with any matter in which he had intervened while in said service. This rule, according to the Presidential Commission on Good Government versus Sandigan Bayan in GR numbers 151809-12 of April 12, 2005, which traces its lineage to Canon 36 of the Canons of Professional Ethics, entitled Retirement from Judicial Position or Public Employment. A lawyer should not accept employment as an advocate in any matter upon the merits of which he has previously acted in a judicial capacity. A lawyer, having once held public office or having been in a public employ, should not, after his retirement, accept employment in connection with any matter he has investigated or passed upon while in such office or employ. This rule correctly disfavors lawyers who may switch sides. It is claimed that switching sides carries danger that former government employee may compromise confidential official information in the process. Thus, in Pasok versus Zapatos of AC number 7388 of October 19, 2016, the Supreme Court held that the restriction extended to engagement or employment. The respondent could not accept work or employment from anyone that would involve or relate to any matter in which he had intervened as a judge, except on behalf of the body or authority that he served during his public employment. The restriction as applied to him lasted beyond his tenure in relation to the matters in which he had intervened as judge. Accordingly, the fact that he was already retired from the bench or that he was already in the private practice of law when he was engaged for the case was inconsequential. He should have maintained his ethical integrity by avoiding the engagement by the defendants. In the summer of 1951, Charles Rydell once said, "The order of society rests upon the administration of the law." Yes, we cannot agree less of the fact that what our society needs is a government under law. The absence of judicial function makes legislation powerless and executive power to be without any limitations. According to Justice Edward G. Ryan of the State Supreme Court of Wisconsin, society has instituted and set apart a body of men trained to the knowledge and practice of law, learned in its principles and processes. First, to interpret the law to society. Second, to guide the business of society under law. Third, to protect the legal rights of the society and its members. Fourth, to look for the intelligent and faithful course of judicial proceedings. And fifth, to stand charged with the holy office of the administration of God's justice among men. Therefore, the legal profession is the guardian of life, liberty, and property of the people who are the integral component of society. In order for a lawyer to display such ethical commitment to the society, a lawyer must be honesti vivere, that is, to live honestly; neminem ledere, that is, to harm no one; and suum cuic tribuere, that is, to render everyone his due. As an officer of the court, whilst an advocate of justice, a lawyer should not compromise the ethics imbibed within the legal profession. And so, allow us to close this presentation with a prayer of St. Thomas More, patron of lawyers, author of Utopia, which was published in 1516, and a martyr. Lord, grant that I may be able in argument, accurate in analysis, strict in study, candid with clients, and honest with adversaries. Stand beside me in court, so that today I shall not, in order to win a point, lose my soul. Amen.